Can one co-owner stop the rest of the family from giving their shares of inherited property to another sibling? No. Under North Carolina law, one co-owner usually cannot block the other co-owners from giving or selling their own inherited shares to another sibling. Each co-owner owns a separate undivided interest. That means a sibling can sign a deed transferring that sibling's own share even if another family member refuses to sign. But the deed only transfers the share of the person who signs it. It does not transfer the holdout's share, and it does not make the receiving sibling the sole owner. Instead, the receiving sibling becomes a co-owner with the holdout. If the holdout will not voluntarily transfer their share, the family's practical options are usually a negotiated buyout, a written settlement, or a partition proceeding. In a partition case, any co-owner can ask the court to divide the property, or, if division would cause substantial injury, order a sale. A forced sale is not automatic. The court looks at whether the property can fairly be divided before ordering it sold. Also, if one family member or a child is living in the property, living there does not automatically create ownership. But occupancy, expenses, rent, and access can matter in negotiations or in a partition case. So the short answer is this: the holdout can keep their own share, but they generally cannot stop everyone else from transferring theirs.